An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know by Randy Barnett and Josh Blackman.
Economic Liberty in the Progressive Era. Muller v. Oregon, 1908. Buchanan v. Warley, 1917. And Adkins v. Children's Hospital, 1923. As the 19th century drew to a close, the progressive movement began to successfully lobby the states and later Congress to enact new political, economic, and social reforms. In earlier topics, we studied how federal progressive laws were challenged for exceeding the scope of Congress's enumerated powers. In this topic, we will study how state progressive laws were challenged as violations of the 14th Amendment. Specifically, that these laws deprive people of their liberty without the due process of law. To understand what liberties are protected by the Due Process Clause, we have to understand how the 14th Amendment was designed to protect liberty. Recall that the Civil Rights Act of 1866 expressly guaranteed that all citizens of every race and color shall have the same right to make and enforce contracts. Many framers of the 14th Amendment understood that the Privileges or Immunities Clause would protect the right to contract. Indeed, butchers in New Orleans argued that the right to exercise their trade was a privilege or immunity of citizenship. Likewise, Myra Bradwell argued that the 14th Amendment protected her right to practice law as an attorney in the courts. However, the Slaughterhouse Cases, 1873, rejected those arguments. In a 5-4 decision, the court limited the Privileges or Immunities Clause to a narrow set of federal rights. As the 19th century drew to a close, the Supreme Court began to compensate for the weakened Privileges or Immunities Clause by expanding the scope of the Due Process Clause. For example, in Lochner v. New York, 1905, the Supreme Court recognized that the 14th Amendment protected the right to contract, not as a privilege or immunity of citizenship, but as a liberty protected by the Due Process Clause. Following Lochner, the Supreme Court decided 3 important economic liberty cases. Muller v. Oregon, 1908, Buchanan v. Warley, 1917, and Adkins v. Children's Hospital, 1923. Oregon enacted a law that made it a crime to employ a female worker for more than 10 hours a day. The owner of the Lace House Laundry challenged the law as a violation of the 14th Amendment. Recall that in Lochner, the Supreme Court found that the Bake Shop Act violated the Due Process Clause. That decision split 5-4. Yet, only 3 years later, in Muller, the Supreme Court unanimously upheld the maximum hour law for women. Study guide. What distinguishes the maximum hour law that was upheld in Muller v. Oregon from the Bake Shop Act that was invalidated in Lochner? Can these two cases be reconciled? Justice Brewer's majority opinion in Muller explained that the differences between the sexes can justify a different rule respecting a restriction of the hours of labor. This statement is reminiscent of Justice Bradley's concurring opinion in Bradwell v. Illinois. He wrote, "The civil law, as well as nature herself, has always recognized a wide difference in the respective spheres and destinies of man and woman." Justice Brewer based his conclusion about the distinction between men and women in the workplace in large part on a brief submitted by Louis Brandeis. At the time, Brandeis was one of the most famous progressive litigators. The brief did not make legal arguments, but instead presented excerpts from social science writings and other data in support of the Oregon statute. For example, Brandeis argued that because of the physical differences between men and women, there was a bad effect of long hours on health. Indeed, there were specific evil effects on childbirth and female functions from working too long. Therefore, the state could justify the maximum hour law to protect women and future generations. Many of the claims in the brief were absurd, even at the time. For example, Brandeis asserted that there is more water in women's blood than in men's. Therefore, women are physically inferior to men. Yet, Justice Brewer's majority opinion accepted Brandeis' sociological information. The court even cited Brandeis' brief in a footnote. Such pleadings, filed in support of progressive legislation, came to be known as Brandeis briefs. In 1916, President Wilson would appoint Brandeis to the Supreme Court. In 1917, the Supreme Court decided another economic liberty case, unanimously, Buchanan versus Warley. However, this case reached a very different result than did Muller. The city of Louisville, Kentucky, prohibited black people from buying homes in predominantly white neighborhoods. The law likewise prohibited white people from buying homes in predominantly black neighborhoods. The government defended this exercise of the police power because maintaining racial purity tends to promote the public peace by preventing racial conflicts. Charles Buchanan, a white man, was prohibited from selling his home to William Warley, a black man. Buchanan challenged the Louisville Ordinance in court as a violation of the 14th Amendment. Because of Plessy v. Ferguson's separate but equal rule, Buchanan could not state a claim under the Equal Protection Clause. After all, the ordinance applied equally to all races. In addition, Buchanan also claimed that the ordinance deprived him of property without the due process of law. Specifically, he contended that the ordinance reduced the value of his home by limiting whom he could sell it to. We've already studied how the Supreme Court compensated for the weakened Privileges or Immunities Clause through a robust application of the Due Process Clause. In Buchanan, the court made a similar move to compensate for the weakened Equal Protection Clause. All 9 justices agreed that the Louisville segregation ordinance violated the Due Process Clause of the 14th Amendment. Justice Day's majority opinion explained that the police power, broad as it is, cannot justify the passage of a law or ordinance which runs counter to the limitations of the federal Constitution. First, he looked to the Civil Rights Act of 1866, which protected the right of all citizens, of all races, to convey real and personal property. Second, Justice Day explained that the 14th Amendment, ratified 2 years later in 1868, was designed to protect the right of a colored man to acquire property without state legislation discriminating against him solely because of color. Third, he noted that the 14th Amendment did not only protect persons of color. Remember, Mr. Buchanan, the seller, was white. Rather, the broad language used was deemed sufficient to protect all persons, white or black, against discriminatory legislation by the states. Therefore, the Louisville Ordinance was not a legitimate exercise of the police power of the state and deprived Buchanan of his property without the due process of law. While the final vote in Buchanan versus Warley was unanimous, Justice Holmes had circulated a draft dissent. Holmes was seemingly indifferent to a statute aimed at barring African Americans from living in white neighborhoods. His draft dissent reflected the same deference towards state police power legislation that he had espoused in his Lochner dissent. In particular, he questioned whether the 14th Amendment protected the rights of a white person to sell his property. He also seemed troubled by the fact that the NAACP engineered this test case. However, Justice Holmes failed to find another justice to join him. Subsequently, he withdrew his draft dissent and joined the majority opinion. Study guide. Does Buchanan suggest the possibility that the court's approach to the Due Process Clause in general, and liberty of contract in particular, could be used to protect members of politically disfavored groups? Muller and Buchanan involved challenges to the state police power. The next case, Adkins versus Children's Hospital of the District of Columbia, 1923, involved a challenge to a federal law. Congress lacks a general police power. However, it can exercise exclusive legislation over the Federal District of Columbia. Pursuant to this power, Congress authorized a minimum wage for female and children workers in the District of Columbia. The purpose of the law was to protect the women and minors of the district from conditions detrimental to their health and morals. In Adkins, the Supreme Court invalidated the federal minimum wage for women by a 5-3 vote. The court did not consider the minimum wage for children. Study guide. How does the court reconcile Adkins with Muller v. Oregon, which unanimously upheld a maximum hour law for women? So far, we've only considered challenges to state laws under the 14th Amendment's Due Process Clause. However, Adkins involved the 5th Amendment's Due Process Clause, which limits Congress's powers. Study guide. Is there any difference between the court's protection of liberty under the 5th and 14th Amendments? The court found that the federal law deprived women of their liberty, that is, the right to contract about one's affairs, without the due process of law. Justice Sutherland, writing for the majority, explained that the Fifth Amendment gives employers and employees an equal right to obtain from each other the best terms they can as a result of private bargaining. He found that the federal law interfered with the right of women to negotiate for a salary that was lower than the minimum wage. A political cartoon at the time ridiculed Adkins as protecting a constitutional right to starve. Yet, Justice George Sutherland, who had been a strong proponent of women's right to vote, viewed the situation very differently. He observed that since Muller v. Oregon was decided in 1908, the differences between the sexes have now come almost, if not quite, to the vanishing point. Justice Sutherland concluded that women of mature age cannot be subjected to restrictions upon their liberty of contract that could not lawfully be imposed on men under similar circumstances. During his tenure in the Senate, Sutherland had introduced the 19th Amendment, which extended the vote to women nationwide. In his opinion, Justice Sutherland explained that the 19th Amendment had ushered in revolutionary changes in the contractual, political, and civil status of women. He added that the ancient inequality of the sexes, suggested in Muller, has continued with diminishing intensity. Finally, Justice Sutherland admitted that there is, of course, no such thing as absolute freedom of contract. However, violations of economic liberty can be justified only by the existence of exceptional circumstances, and no such circumstances existed here. Rather, the minimum wage law is so clearly the product of a naked, arbitrary exercise of power that it cannot be allowed to stand under the Constitution of the United States. The Adkins Court articulated the presumption in favor of liberty even more clearly than did the Lochner Court. Unlike Muller, which was unanimous, Adkins resulted in 2 dissenting opinions. Chief Justice William Howard Taft's dissent echoed Justice Holmes' dissent in Lochner. He wrote, "It is not the function of this court to hold congressional acts invalid simply because they are passed to carry out economic views which the court believes to be unwise or unsound." Justice Holmes, in dissent, again found that the statute was reasonable and must be upheld. First, he said that the ends of the law, that is, the removal of conditions leading to ill health, were permissible. Second, he observed that the means, a minimum wage, were likewise permissible, because such laws were used across the country. When so many intelligent persons who have studied the matter more than any of us can have thought that the means are effective and are worth the price, it seems to me impossible to deny that the belief reasonably may be held by reasonable men. In conclusion, Justice Holmes could perceive no difference in the kind or degree of interference with liberty between the maximum hour law upheld in Muller and the minimum wage law struck down in Adkins. Less than a decade later, during the New Deal, the Supreme Court would reverse course on the protection of economic liberty and overrule Adkins.